Okay, so Dred Scott, that was the result of James Buchanan, President James Buchanan, who was a Northerner with Southern sympathies, I guess is what they call him. I think there was another term they used to use for them, kind of derogatory term. He had this idea, hey, we're going to go ahead and have this case go before the Supreme Court. He pushed for it somehow. And Dred Scott, it was kind of like a voluntary manumission type of thing or something like that, where this southern slave owner had moved to a northern state. In the northern state, they didn't allow slavery, and then he wanted to force his slave to come back across the border with him. I think I'm saying that right. I'm not an expert on the Supreme Court cases, and I consider them to be of minimal value to me when it comes to understanding the Constitution. When it comes to understanding the corruption of the Constitution, yes, they're incredibly valuable. So anyhow, the idea was President Buchanan thought, okay, let the Supreme Court settle it. Then once the Supreme Court says, hey, no, you can't do this, you can't do that, then everybody will just have to accept it, and they'll be okay, and we can move on to the next battle. That worked out great, didn't it? Yeah, Dred Scott worked out just fantastic, Judge Dredd. It didn't. I don't think Barron v. Baltimore worked out worth a dang either. Now that didn't intend to become a ruling on the Constitution, but unfortunately everybody treated it like it was a legitimate meaning of the Constitution. The case was brought by William Wirt. He was the longest-serving former Attorney General. You can say, well, okay, the First Amendment starts off this way, yes, but each amendment was passed individually as its own individual amendment. If they didn't copy and paste, Congress shall not, from the First Amendment into the Second, Third, Fourth, Fifth, and Sixth, etc., then, it just doesn't. I'm sorry, dudes. And you can say, nah, the Constitution only existed to control the federal government. Baloney. Article 1, Section 10. Read it. It's not that complicated. Or Article 1, Section 4, where the federal government's allowed to override the elections laws. Or Article 2, in Section 1, and the portion, I can't remember which clause, where the Congress can override the times of the electors, what have you, regarding electing the president. Or Article 4, Section 2, Clause 1 has basic requirements on the states. Or Article 6, Clauses 2 and 3. I'm sorry, dudes, it doesn't take its genius to figure this out. Yes, the Constitution by nature placed restrictions on the states and allowed the federal government to exercise authority on the states. And so, I don't care. They say that there's a theory out there, I haven't looked into it a ton, that, this was a year after the nullification crisis, which Andrew Jackson then had really made the courts kind of feel an identity crisis about who they were and how powerful they were. I can see that. But again, it was never the point of the Constitution. They kicked around the idea of creating up something to define the Constitution for us, to solve questions of constitutionality in the Constitutional Convention, and nothing like that ever made it into the text of the Constitution. Instead, what you get is Article 6, Clause 3. Article 6, Clauses 2 and 3, right? So, Barron v. Baltimore was a disaster. 14th Amendment supposedly fixes that. But I think that the Constitution, the laws, and the treaties are the supreme law of the land when they're in pursuance of the Constitution. And it doesn't matter what the states are doing, it's not superior to the federal government in the moment that the federal government is exercising the powers granted to it according to the Constitution. And the Constitution puts a blanket prohibition on something, and that Constitution is the supreme law of the land. You can say there was no enforcement mechanism. Baloney, dude. There was, look, anything, if the Constitution is part of the supreme law of the land, it's part of a law. That's all there is to it. So therefore, you've got the Take Care Clause in Article 2, Section 3, and then you've got the Article 1, Section 8, Clause 15, which is another basic enforcement mechanism, provide for calling for the militia to execute the laws of the land. The Constitution, of course, being the supreme law of the land, and so therefore anything that it promises, anything that it prohibits, with or without Article 1, Section 7, Clause 2 legislation should be good for the federal government to deal with it. But then you'll be like, okay, is it allowed to go before the courts? Well, read Article 3, Section 2, Clause 1. The judicial power of the United States, not the Supreme Court power, the judicial power of the United States, shall apply to all cases in law and equity arising under this constitutional laws and the treaties. So basically, you have cases in equity, cases in law. Cases in equity are basically where something wrong is being done, and the laws don't specifically have details for how to deal with punishing it yet, but it violates clearly constitutional promises, right? And so, yeah. So anyhow, this is me giving my quick rundown. You know, you can double check me on my things I'm saying here, but I've worked pretty hard at developing this. So I think the Supreme Court doesn't do that great of a job of solving anything. They tend to take square pegs and plug them in round holes, and then when they have a round peg for a round hole, they tend to say, no, that's not square enough. So this is silly. They don't take up the cases where they should take them up. Joseph Smith said, anyone having taken a oath to the Constitution, failing to defend the rights of the Constitution promises, should be possibly subject to the death penalty, right, for abdicating their duties. So now look, I want you to read the Declaration of Independence. What's the attitude of the Declaration of Independence towards importing this, towards importing that, towards leaving the borders open, towards not allowing us to control our internal, but enforcing us to deal with what you bring in from the external, right? Yeah, they weren't okay with it. Okay, so President Trump, he's looking at the Constitution. He says it's for ourselves and our posterity, and that there are laws regarding immigration and naturalization, which are laws justly granted in Article Section 8, Clause Section 9. And he sees that he has the take care clause. This isn't a suggestion, it's he shall take care. He sees that there's a promise to protect from invasion. Which, I mean, read the Declaration of Independence. It doesn't take a genius to figure this out. Government that does not protect from invasion is no government at all, but is tyrants and is owning the people like they're slaves, right? Owning the entire population of the country like they're slaves, okay? That's really it. They're telling us, you've got to obey us, but we don't got to do jack for you, right? That's not the way it goes. So, anyhow, President Trump did the right thing to bring this case, this Barbara versus Trump, or whatever it is, Trump v. Barbara. Yeah, no, he did the right thing. That's literally his presidential duty, to look at this conflict. Okay, now let's talk about these dual citizenship type of concept. Look, these were the original concerns that even kept the founders from just doing a blanket freeing of the slaves and then taking all those slaves and just letting them become permanent residents of the United States. They're like, you know, we're supposed to set up the only valid purposes of government are to take care of the citizens and to protect them from invasion, right? To not to exercise excessive authority over the citizens and not to subject them to all sorts of threats and risks, right? And so this was not racism like from this, I mean, for some of it was, but not for all of them. For some of it was just a pure concern. What about the divided loyalties? What about the lack of loyalties? What about this? What about that? Right? That's fair. If you're a father and you have a house and you're supposed to be taking care of your kids and your wife, and some other kid asks to come live at your house, you don't know who that kid is. You could be like, well, I got to be charitable. Do you? What are you doing? Are you taking care? Are you going to abdicate your responsibility to take care of your kids for the sake of charity? Right? It doesn't make sense. So, anyhow, I think that the concerns were valid from the start, and I do not hold it against the founders at all. You know, Liberia and all that kind of stuff, it only worked out so well. It wasn't exactly the best thing in the world results-wise. But can we have a little bit of common sense understanding? Can we have a little bit of common sense understanding of why Trump brought this case, you guys? I mean, this is encouraging a whole nother something that didn't exist at the time. Plus, to top it off, I'm going to complain. You cannot hold the governed to answer to incomplete text. You either wrote it out for us or you didn't write it out for us, okay? And so the first section of the 14th Amendment, it reads in present tense, and that's it. And that's because there was a real problem going on in the present. And then to top it off, subject to the jurisdiction thereof are citizens. Subject and citizens were two completely different concepts, related in their own right, but a citizen has a lot more rights. A subject is someone who just owes allegiance, right? You're saying that someone born freshly in the United States owes allegiance to it, right? That they have no divided allegiance whatsoever, right? I don't think so. That's crazy. I think if you look at the statistics right now, and this is again not racism on my part, not mean racism, not white supremacy type racism. This is just pure common sense. If you were to ask the average descendant of the slaves who were freed how much they love America and are proud of it, how much they have allegiance to America, I think you'd run into the exact problem the founders were concerned about. And to subject the internal citizens to that is a major concern and a valid one. I think the right decision was done, right? Inspired amendments, as Dallin H. Oaks says. But can we at least have a little bit of common sense understanding about the proper role of government, right? And then to top it off, I mean, like, I think even with the others, the Native Americans, what have you, you know, you grant them citizenship, everything like that, which was the right thing to do. But that whole subject, that allegiance thing, right? I think that, I don't know, research it. You guys research it. You tell me. Can we at least understand where the concerns came from? And where President Trump has his concerns right now. Say, for example, somebody birth tourism. Apparently it's a real thing. Somebody gets born here, taken and raised with the culture of a completely separate country. I'm sorry, can we look at the Declaration of Independence grievances again? So you're going to like raise them over there, indoctrinate them over there, and then bring them over here and impose them on us like they're citizens suddenly, with our values, without making them, you know, I mean, I'm sorry, dudes. This is common sense. President Trump did the right thing. He did his duty, and he's probably going to keep going at it because he's that kind of president. And anyhow, I love people from all countries. I want them here if they want to be here legitimately. Joseph Smith said we should annex Texas if they really want to become part of the Union. We should allow the Western territories to become part of the United States if the Native American tribes really want to become part of the Union. If they really want to, right? But then, you know, when you make them want it first, now you've got this like beautiful allegiance, right? If they're just coming here disrespecting the laws, just coming straight in without the usual proper procedures, etc. I mean, the consent of the governed either matters or it doesn't. The consent to the governed was given to a certain set of procedures. They weren't given to other procedures, okay? To exercise powers that aren't given by the consent of the governed, yes. Do governments do it? Yes, all the time. As is evidenced by what John Roberts just did, and all those others. They just basically tell you, yeah, no, you've got to answer to this whether or not it's really the right thing. So, and I think a lot of us, we grew up around a lot of people that are the result of, parents who came here illegally, and but the kids got birthright citizenship out of the way we were interpreting the Constitution, and we love those people. You know, so this is not a racism type of thing. We're just saying it was never really the way the Constitution was supposed to work, and can we now recognize that it's getting out of control? We don't have to fix it retroactively, but can we at least stop it and come up. Let the legislature do their job. Stop fitting square pegs in round holes, because when you start taking old laws that were meant to deal with a completely separate issue and making them fit a modern issue, that's what the Supreme Court has to do, because they're literally given no legislative powers whatsoever. So in order for them to legislate, they have to come up with interpretations of past laws, which we would call out a square peg in a round hole. Doesn't take a genius to figure this out, you know? So anyhow, that's my thoughts for you. All right, you guys. Thanks for listening. We'll see you later.